In Cook County, landlords cannot legally use your criminal history as the only factor in deciding to rent to you. Just housing is a part of the Cook County Human Rights Ordinance. It sets rules for the rental application process. It protects the rights of people with criminal records. Before you fill out your next rental application, here's what you need to know. A landlord is not required to conduct a criminal background check, but if they do, they can only consider recent criminal history, something from the past 3 years. They cannot consider an arrest without conviction, even a recent one, or a record that's older than 3 years. And if an applicant's criminal history is less than 3 years old, the landlord must take the time to look into their background for signs that they can be a good tenant in spite of their criminal history. This is called the individualized assessment, and we'll explain it more later. There are exceptions to these rules. Your rental application can be denied if you or someone you live with is a registered sex offender or a sex offender with restrictions on where they can live. Here are the facts. Asking for criminal histories is not the first step in a rental application process. Landlords must first tell applicants the steps to be approved to rent. Give applicants a copy of the Just Housing Ordinance. Pre-qualify applicants based on criteria such as wages and rental history. A prospective landlord cannot consider criminal history to pre-qualify you. The application cannot ask if you have a criminal history. The landlord must take these 3 steps before collecting an application fee. After you pay the application fee, the landlord uses their selection criteria to pre-qualify your application. When your application is approved, the landlord must tell you if they will conduct a criminal background check. After receiving a criminal background check, the landlord has 5 business days to give you a copy, in person, by certified mail, by text, or by email. Once you get a copy, you have 5 business days to dispute the criminal background check. Once the landlord gets your dispute, they have 3 business days to accept or deny your application. If your record includes convictions or incarcerations from the previous 3 years, the landlord must complete an individualized assessment before making a decision. The assessment covers 9 areas, including an overview of your criminal offense, the time since your most recent conviction, and your tenant history since conviction. Juvenile records cannot be considered. Landlords must also consider evidence of your rehabilitation as part of the individualized assessment. Examples include programs or trainings you've completed, reports from your employer, facility or support services, and personal recommendations. The landlord must complete the individualized assessment, then approve or deny the rental application within 3 business days. If your housing application or lease renewal is denied based on your criminal history within the past 3 years, the landlord must explain their reasons in writing. The landlord must state why the denial provides protection against a clear risk to personal safety or property. And the landlord must tell you about your right to file a complaint. If you feel that you have been denied your rights under the Just Housing Amendment, you can file a complaint with the Cook County Commission on Human Rights. You may also file a civil complaint. Questions? ILAO is here to help. For more information, visit IllinoisLegalAid.org.